In this video, I'm going to walk you through the process of obtaining a power of attorney in Pennsylvania. I'll cover the different types of power of attorneys, the essential requirements, and the benefits of using statutory forms. So by the end of this video, you'll be able to confidently create your very own power of attorney. And by the way, if you feel like you need help creating power of attorney, then I recommend you reach out to people from lawdepot.com because they are professionals and they will be able to help you. For your convenience, I'm going to leave a link to their website down in the description of this video. And with that in mind, let's get right into it. Understanding Pennsylvania's power of attorney laws. Before I explore how to obtain a power of attorney in Pennsylvania, it's essential to grasp the basics. A power of attorney is a legal document that grants specific powers to an agent, enabling them to act on your behalf in various areas such as finances, property, and legal matters. Types of power of attorneys in Pennsylvania. In Pennsylvania, you can create various types of power of attorneys, but two commonly used ones are financial power of attorney. This grants your agent the authority to manage your financial and business affairs, and healthcare power of attorney, often referred to as the designation of healthcare surrogate. This allows someone to make medical decisions on your behalf. Most estate plans in Pennsylvania include durable power of attorneys, which remain effective even if you become incapacitated. Legal requirements for a financial power of attorney in Pennsylvania. For your power of attorney to be valid in Pennsylvania, it must meet specific legal requirements. Mental capacity. While Pennsylvania requires the person creating the power of attorney to have mental capacity, the exact criteria have not been strictly defined by state statutes. Probate courts, referred to as orphans courts in Pennsylvania, have emphasized that the person should understand the nature of the authority they are granting, the assets covered by the power of attorney, and the information and warnings on the first page of the power of attorney. Statutory language. Pennsylvania mandates the inclusion of certain notices in the power of attorney. Reputable software programs or local attorneys typically include this required language in the power of attorney. Witnessing and notarizing. The power of attorney must be witnessed by two individuals who are not named as agents and signed before a notary public. Witnesses must be over 18 and cannot be involved in helping you sign the document. Named agents in the POA or notary public. Acknowledgement signed by agents. Your agent must sign an acknowledgement which is then attached to the power of attorney. This step ensures that your agent comprehends their responsibilities. Your agent need not complete this acknowledgement until they need to use the power of attorney. Steps for obtaining power of attorney in Pennsylvania. Here's a step-by-step guide on how to obtain a power of attorney in Pennsylvania. Step number 1. Create the power of attorney. You can create your power of attorney using specialized software or by consulting an attorney. LawDepots.com offers a free and user-friendly platform where you can customize your power of attorney form according to your specific needs and in compliance with Pennsylvania's legal requirements. Step number 2. Select your powers. When crafting your power of attorney, specify the powers you want to grant your agents. These can include managing real estate transactions, financial decisions, retirement plans, securities transactions, business operations, and more. In Pennsylvania, a power of attorney is durable by default, meaning it remains effective even after your incapacitation unless you state otherwise in the document. Step number 3. Sign the document. In Pennsylvania, you must notarize the power of attorney and have it witnessed by two individuals over 18 who are not named agents, not helping you sign, and not the notary public. Step number 4. Store the original power of attorney safely. Once completed, store the original document in a secure place that trusted individuals can access easily. Make sure your loved ones know where to find it, as the original power of attorney may be required if you become incapacitated. Step number 5. Provide a copy to your agents. Share a copy of the power of attorney with your designated agents, ensuring they are familiar with its contents. Step number 6. File a copy with the Land Records Office, if applicable. If your agent's powers include real estate transactions, file a copy of the power of attorney in the office of the Recorder of Deeds in any county where you own real estate. This ensures your agent's authority is recognized in real estate matters. Step number 7. Share with financial institutions. Consider providing copies of your durable financial power of attorney to banks and relevant institutions where your agent may need to take action on your behalf. This step can streamline the process in case your agent needs to use the power of attorney. Note that some banks may have specific requirements for accepting power of attorneys. Choosing an agent in Pennsylvania. Legally, you can appoint any competent adult as your agent in Pennsylvania. However, practical considerations such as trustworthiness and proximity should be taken into account when making your selection. While Pennsylvania allows co-agents, having a single agent is usually advisable to minimize potential conflicts. Nonetheless, naming a successor agent, an alternate who steps in if your first choice is unavailable, is recommended to create a backup plan. When does a durable financial power of attorney take effect and end in Pennsylvania? In Pennsylvania, a durable financial power of attorney takes effect immediately upon signing unless you specify otherwise in the document. Creating conditions for the power of attorney to become effective, such as requiring a doctor's declaration or incapacity, is possible but not commonly recommended. A financial power of attorney ends upon your death, revocation as long as you're mentally competent, or if a court invalidates the document due to reasons like lack of mental capacity, fraud, or undue influence. Additionally, if your spouse is named as your agent, this designation ends automatically if you or your spouse files for divorce. Your power of attorney remains intact, but your ex-spouse's authority as your agent ceases. In such cases, if you have named the successor agent, that person would take over. Conclusion. Obtaining a power of attorney in Pennsylvania is a straightforward process when you adhere to legal requirements and utilize a trusted platform like lawdepot.com to create your customized form. By following these steps, you can ensure that your interests are safeguarded and your chosen agent can effectively manage your affairs when necessary. And don't forget that if you feel like you need help creating power of attorney, then I recommend you reach out to people from lawdepot.com. They are professionals and they will be able to help you. I'm going to leave a link to their website down in the description of this video. I hope this video was helpful. Thank you so much for watching. Subscribe.